Welcome to Bloomberg Law. I'm Pacchia. The FBI recently announced that they are currently in the process of building insider trading cases against 120 individuals. This marks a dramatic expansion of its now 3-year-long crackdown on insider trading. Joining me now to discuss is Richard Holwell. He is a former federal judge from the Southern District of New York, and he's the founding partner at Holwell, Shuster Goldberg. Welcome. Thanks so much for coming in today.
My pleasure, Lee.
So we have a big ramp up in cases coming shortly after a period of already increased activity in terms of investigating and prosecuting insider trading in New York. You presided over the largest of those cases, the Raj Rajaratnam case, of course. Why this extra push and why now?
Well, it follows from the Department of Justice's decision to use wiretapping to pursue white-collar crime and to pursue insider trading. Insider trading is, by definition, a telephone-type crime. And once you tap in to somebody's phone who's engaged in it, you find out that all of a sudden you're just following dominoes that fall down as you move from co-conspirator to co-conspirator. Some people have referred to this approach as harvesting the low-hanging fruit.
Right.
And to a certain extent, that's correct. It's just much more straightforward, and it's easier to pursue this type of a crime as opposed to the more difficult issues of the existence of structural defects in the marketplace.
Right. I mean, the wiretapping evidence usage almost seems like a specialized low-hanging fruit picking machine in an environment that we find ourselves in where the fruit's more desirable. I guess people want to see, given what's happened over the last couple of years, they want to see something done about malfeasance on Wall Street. Where do you see this heading? Do you think that this trend is going to be sustained?
I think, as you can see by the numbers, that the Department of Justice and the FBI are using 120 targets, more in the way of subjects in the investigation. We can expect this to continue for several years. There is no reason for them not to. The fact that fruit might be low-hanging doesn't mean that it's less criminal. And the Department of Justice will go where the evidence leads them. And I would anticipate a lot more activity in the area.
In terms of historical context, what does this mean? Is this a huge blip on the screen, or have we been in periods where we've seen these clusters of insider trading cases come along?
It's very hard to give a historical perspective on it. You can hark back to the days of Ivan Boesky, probably the most famous insider trading case prior to this decade. But there, of course, the government had not arrived at the position it now is of attempting to get beyond the very small conspiracy that he was accused of to the dominoes that surrounded him. Now that the government has made a policy decision to employ wiretapping, the government's able to do that. It's hard to tell what the situation was in the Boesky days. It might have been better. It might have been worse. The decision to use wiretapping is certainly a radical decision when you keep in mind that the wiretap statute calls into question a lot of privacy rights in society. And so to go from using wiretaps to pursue the mafia or to pursue the Colombian drug cartels is one thing, but then to step beyond that and use that for people in the business world is quite another. I mean, that is a radical departure.
Right. You said before that insider trading is a telephone crime. That said, do you see the use of wiretap evidence expanding into other financial crimes?
Well, for sure, having made the policy decision to go this step, the Justice Department will attempt to use it in white-collar crime investigations. I think it'll be a lot more difficult, particularly if they attempt to go after the conflict of interest issues that are percolating on Wall Street with respect to deal making, because there you're going to wind up with FBI agents listening to hours of dead tape when nothing very interesting is happening. So it'll be used, but it'll be more selective. But it'll, if they can get it, it will be as much of a game changer as it has been in the insider trading area, for sure.
In taking on these numbers, I mean, 120 sounds like a lot, but I was wondering if you could tell me what it means for prosecutors and regulators. Are they spreading themselves a little bit thin, or is this completely manageable?
Well, the Department of Justice is relying not only on their own capabilities, but they're also working closely with the Securities and Exchange Commission. Keep in mind that the SEC, of course, has access to a lot more trading data than the Department of Justice does, and understands trading patterns far more than a assistant U.S. attorney who's 8 years out of law school. So they will bring, I think, a lot of suspicious cases to the criminal side of law enforcement and attempt to whet the interest of the Department of Justice in pursuing it criminally. And that's how it works. So it'll leverage itself. It won't be just Mr. Holder and his staff.
Do you have any sense as to why they're going after these types of cases as opposed to others? What to make of the prosecutorial discretion here? Is it more about policy or pragmatism at the end of the day?
I think it is largely a pragmatic decision. It is very difficult to go back to the hypothetical 8-year lawyer who happens to be a senior trial lawyer in many U.S. attorneys' offices. Very difficult for them to get their hands around a highly sophisticated, structured transaction and understand how it works, much less determine whether or not any criminal laws have been violated in putting the package together. So it's going to be now. I know President Obama has set up this task force to pursue those issues, and he's reacting, of course, to what you mentioned, the hue and cry of the people for justice. That's obviously something that has to be taken into account. But I think they've got a hard job, a hard row to hoe here.
What does this uptick in white-collar crime cases mean ultimately for the white-collar defense bar? You, of course, were on the bench for the Raj Rajaratnam trial and got to see all the various lawyers come into court and duke it out.
Well,
what does this mean for attorneys working in the white-collar space?
If every cloud has a silver lining, this is a silver lining for the
We always look for one at the end of the day here.
For the criminal defense bar, because for every of those 120 targets that the FBI trumpeted a week or two ago, there are probably 5 or 10 people of interest out there in the weeds who have already retained counsel. So it's a dynamic investigation. In the Rajaratnam trial, we had a full courtroom most days, and I just know from the people I've met over the years that half of them were sitting representing clients who had an interest somewhere in the case. So it'll be an employment act of sorts for the criminal defense bar here.
Right. I would imagine the use of wiretap evidence just revolutionizes the game for all parties involved, but particularly defense counsel. Is that, did I get that right, or is an insider trading case still an insider trading case at the end of the day?
When you listen to a tape in the courtroom, and you could record me speaking to my wife about what we're having for dinner, the effect is palpable. It's a scratchy recording. You're a defendant in the dock. Almost whatever you say sounds bad, and the overtones are negative. It's very powerful evidence in any trial, and it'll be very powerful evidence in the future insider trading cases that are brought to court.
All right. Well, Rick, thanks so much for coming in today.
My pleasure.
Thank you. That's Rick Holwell, founding partner at Holwell, Shuster Goldberg. For more information about this and other topics, log on now to BloombergLaw.com. You can see our recent videos at YouTube and follow our daily updates on Twitter. I'm Pacchia. Thanks for joining us.